Counsel can begin when you're ready.
Thank you, Your Honor. Your Honor, my name is Mike Bell, and I represent Paul Howard Company. I'd like to reserve a couple minutes of my time. Two should be sufficient for rebuttal in the event that's necessary. I'm here today to ask this Court to reverse an order the trial court entered in 2010, granting Howard's motion to tax costs. The trial court awarded Howard $20,847 in taxable costs for the 14 years or so that this case was pending before the trial court. In our view, this Court should reverse the trial court's order, remand this to the trial court for further proceedings, or in the alternative, remand it to the trial court and instruct the trial court to enter judgment in Howard's favor in the amount of $81,627. This case has a very long procedural history. I know, Judge Griffin, you're very familiar with it. It was filed in February of 1994. The first trial court judge gave Howard summary judgment. That was reversed by this court. It was remanded for a trial. There was a trial in 2001. Following that trial, the next trial court judge, who presided over the first trial, granted summary judgment in favor of Howard, and that was reversed by this court. This court, and I believe it was your opinion, Judge Griffin, remanded this back to the trial court for a second trial where specific questions were to be addressed by the jury. That trial was held in August of 2008, and it was resolved in Howard's favor. Subsequent to judgment being entered, there was an appeal before this court. A per curiam affirmance was entered in 2010. There were motions filed by CDM subsequent to that for rehearing en banc, clarification. Those motions were all denied by this court in May of 2010. After the appeals were finalized, we scheduled a hearing on Howard's motion to tax cost for August 31 of 2010. That motion had been filed back in 2008, but had been sitting dormant until the appeals were resolved. I supported that motion with an affidavit that I signed indicating that Howard had expended some $121,000 in costs from 1994 through the second trial in 2008. There was no memorandum of law or memorandum in opposition to the motion filed by CDM, and there were no informal discussions of settlement between counsel. So we didn't know what CDM's position was until we appeared before the fourth trial court judge who was to address this matter. At the hearing, CDM had two gripes, if you will, with Howard's costs. The first being, you shouldn't be allowed to tax costs for experts who didn't testify at the second trial. Their second gripe, if you will, was that Howard wasn't entitled to costs relating to the 2001 trial and costs incurred prior to that trial. Now, after the hearing, I submitted a letter to the judge and with a proposed order indicated that I thought the first argument raised by CDM was well taken. And instead of entering judgment for $121,000, the form of order I submitted requested that the trial court judge enter judgment in Howard's favor for some $80,000. CDM submitted their own order. In their order, they virtually gutted all of the expert costs and all of the costs incurred with regard to the first trial. And their order provided that Howard should only receive costs of some $20,000. The trial court signed that order, this appeal. We think the trial court was wrong because we think that Howard is entitled to costs, all reasonable costs incurred throughout this proceeding that has gone on for, 18 years now, a little more than that actually. And in support of that position, we point out in our brief the statute 57.041, which indicates that once you obtain a judgment, you should be awarded all costs. Of course, that'd be subject to the uniform tax lines, uniform guidelines for the taxation of costs, which is advisory to the trial court judge. But addressing the specific issue here that is our gripe, if you will, on appeal, and that is we think we're entitled to all reasonable costs, even those relating to the 2001 trial. We directed
They're simply asking that the case go back for a hearing on costs to determine what the costs would be for the 2001 trial. Or do you, the trial court denied it in toto, right?
Yes, sir.
So there was never any finding by the trial court as to what cost would have been. He just said because it was the 2001 trial, you're not getting anything for that. So you're requesting a hearing if you prevail for the trial court to make appropriate cost awards for the 2001 trial?
I think that would be the most appropriate thing to do. Yes, Your Honor, I do. We feel that there's several cases that we cite that stand for the proposition we're advancing here today. There's the Otis case. In that case, the plaintiff was awarded costs by the trial court for 2 trials. On appeal, that was affirmed. The first case ended in a mistrial. The second case we bring the court's attention to in our brief is the Mack trial. It was a medical malpractice trial down in Palm Beach County. The plaintiff obtained a verdict in both of those trials. The trial court only awarded costs for the second. The 4th District reversed, saying he should have awarded it for all. And lastly, the Higgs case we cite for, it's a very interesting case, involves a property appraisal matter. I guess that sort of doesn't really follow, does it? There could be an interesting case on property appraisal. But in any event, the trial court awarded or agreed with the property owner on the assessment, and then subsequently on a motion for rehearing dismissed the entire case because it lacked jurisdiction. Apparently the property owner hadn't paid his back taxes for a previous year that wasn't in question. But in dicta, what that court talks about is it doesn't matter the basis for the judgment. It's just the mere existence of the judgment that entitles the party to tax costs. So if there are no questions from the panel, I'll just close by saying this. 14 years, $121,000, attorney's fees of $300,000. Howard, this court should attempt to make Howard as whole as possible, even if that's only $80,000, or whatever the trial court ultimately determines, but certainly more than the $20,000 the trial court awarded.
Thank you, counsel.
Thank you.
Good morning. May it please the court, counsel. I am William Seldy from the Office of Sedora Daily, Sedora, Omaha, Nebraska, and with me is our Florida attorney, James D. Kissio.
Interesting answer brief, Mr. Seldy, because on an appeal on a cost judgment, your answer brief basically doesn't talk about costs at all.
Judge, we brought the issues forth in our answer brief based upon the proposition that Judge Kirkwood didn't abuse discretion in entering the judgment for $20,000, but in fact, because the underlying proceedings that are the basis for his judgment are fundamentally flawed under the 7th Amendment. And so we submitted to the court a pretty concise brief.
Based upon opinions out of this court, Kirkwood was operating based upon a series of litigation that had lasted for a number of years, including an affirmance from this court.
Yes, Judge, but it is in fact the affirmance of this court that sets in the record the fundamental flaw. Because
so really the fundamental flaw starts with the affirmance from this court. That's what you're suggesting, correct?
Judge, it really starts with Judge Grizzly bifurcation.
But that starts here. You're really complaining about the per curiam affirmance.
What it does, Judge, is the per curiam affirmance establishes for this court that, in fact, 2 juries considered the identical issues, which is contrary to the fundamental rights under the 7th Amendment. And by having the PCA from this court in regard to the 2008 jury trial, it sets in the record and establishes for us that, in fact, by virtue of the process from 19...
Why didn't you file a cross appeal?
That's a good
question. If that's what your claim is, why didn't you file a cross appeal? You didn't do that, did you?
We didn't do that, Judge, because we're not appealing we weren't contesting...
Yeah, but you're making the same arguments that seems to me that should be made in a cross appeal, and you didn't file one. It seems to me what we have here is if there's a judgment, or they're entitled to their costs. All these issues that you're talking about, well, it was fundamentally unfair and the bifurcation, that's water behind the bridge. I mean, we don't consider that now. We look at whether there's a judgment where they're entitled to the costs. But
for the fact that fundamental error, as we believe we've established in the record, can be raised at any time, Judge, and that fundamental error that we believe is established by the record can be raised on the court's own motion, the cross appeal would be a significant issue. But what we by virtue of our answer.
Don't you think you should have filed a cross appeal if you wanted to raise those issues?
Judge, we filed a responsive brief to the plaintiffs, the appellants appealing of this $20,000 order from Judge Kirkwood based on the fundamental flaws that substantiate this $20,000 award. Without talking about the issues that Judge Kirkwood considered, we go one step below to say, over the course of 18 years of litigation here, we started out with an error at the trial court for CDM1, and that was reversed and remanded and corrected by this court. We had a jury trial after bifurcation by Judge Gridley, and a decision by Judge Gridley that in fact maps the confusion, the intertwined issues of actual liability and potential risk that confounded the circuit court throughout the course of this time. We obtained some clarity from this court in CDM2 opinion, but unfortunately it was incomprehensible to us that that opinion would be read in an effective vacuum. No considerations were made by the circuit court as to the established law of the case, the scope of the proceedings, and we went forward in 2008 over our objections to have a jury trial on regular and general negligence questions, which were clearly inappropriate outside the scope of the mandate.
That was appealed and that was affirmed.
It was, Judge, and that ties us, that binds this court.
That ends it.
And bound us to having a jury consider actual liability on two occasions, which is a clear violation of the Seventh Amendment rights of the plaintiff appellee in this case. What we had, Judge, was when we obtained jury questions in the 2008 trial, and the jury asks the court and counsel, what does it mean if found 1% negligent, it is liable for 100% of damages, and then they ask, is that a fact? Then they go on to ask the court and counsel, after the 2008 proceedings, would they have had to have paid for non-design issues if acknowledged guilty of only design in court? And what that demonstrates for you, Judge, in the record, and after the affirmance, is that the 2008 jury trial improperly reconsidered the alleged apparent re-examined guilt for only design by Camp Jefferson McKee. Judge, we know, by virtue of the 2001 liability trial, Camp Jefferson McKee obtained a jury verdict for no design negligence, no design liability, yet in 2008 the jury reconsidered it, made the opposite determination, and then denied any damages on potential risk. So we can see that these issues are intertwined. We can see this by virtue of the jury questions from 2008 with the adverse verdict. It's in the record. It's set in the record. We can see this because of the confusion and the order of Judge Gridley, where he, without evidence of potential liability, found no potential liability after the 2001 jury trial. We can see this by virtue of the conflict of the evidence and witnesses as we set out in our brief, and we do rely on the issues that we briefed, Your Honor. We can see these issues between actual liability and potential risk or potential liability, which would determine the amount that CDM should obtain based on the contractual indemnity provision of this contract. We can see these are so thoroughly intertwined by virtue of the scope of the proceedings. Must they have been? Don't know. The record before the court fixes them as so significantly and thoroughly intertwined that the bifurcation, the remand after CDM2, the 2008 proceedings conspire to combine to fundamental error, because we had two juries. We were able to document in the record
And
two
so
juries considering this.
What you are asking of this court is to go back to square one.
Exactly, Judge. Would that be our preference? No, Your Honor, absolutely not. But that is our remedy. That is what we must ask this court to do, to vacate, Judge Kirkwood, to vacate the 2008 verdict and even to vacate our favorable verdict from 2001, because as we look at the law, as we look at the federal court cases pertinent here to our Seventh Amendment rights, as we look at this issue of the jury considering, two juries considering the same evidence, that is the remedy, is to vacate even our favorable liability judgment from 2001. Judge, in our brief, we cited In re Rome Polonic. I think we omitted it from the index. It's 51 Fed 3rd, 1293. At page 1392, the judge in the federal court there in the Seventh Circuit relates that for an appellee, for a party, they have rights under this amendment to have the juryable issues determined by the first jury impaneled to hear them and not re-examined by another finder of fact. And we think that's amply demonstrated here in this case. And we think this is the essence of the fundamental.
Is there another reported case where, where the issue is appropriate costs to be awarded, and because they're seeking costs, that gives the opposing party an opportunity to come in and argue to the appellate court that all the judgment should be set aside because they're erroneous, because our constitutional rights were violated?
Judge,
do you have a case that says that that's what we should consider when you didn't file a cross appeal? Or
Judge, it may not go to the issue of we didn't file the cross appeal, but on raising this issue, which we think can be raised by the court or is available to be raised at any time.
Judge Kirkwood, I think, found he didn't give the cost because he said it just wasn't relevant. Now you're arguing, well, everything should be set aside because your constitutional rights were violated.
Judge, if I may.
So, was he wrong when he said it wasn't relevant, or, do you agree that it was irrelevant and that's why the cost should not be awarded?
Mr. Bell, we quoted for Judge Kirkwood Mr. Bell's comments on the relevancy of the 2001 proceeding.
I'm looking at the order, and it says the costs associated with leading up to the trial of 2001 were irrelevant to the issues upon which the defendant prevailed, and therefore disallowed. Do you agree with that? Were they irrelevant? Because that's the basis for his denial of the costs.
Judge, we pointed out to Judge Kirkwood that was Mr. Bell's admonition to Judge McKinnon, and that we believe that's why under the Florida uniform rules that we advocated to Judge Kirkwood that he should dispense with all Mr. Bell's alleged costs from 2001 because
that's what the order says, that he is disallowing the costs because anything leading up to the 2001 trial was irrelevant, and that's what. But I don't see anything in this order that talks about, well, the constitutional rights were violated and all of that. He says it was just irrelevant. Do you agree with that? Was it irrelevant or not? Was this an appropriate ruling? Tell me, was it correct or not? Do you agree with it?
Judge,
irrelevance.
I don't agree that the 2001 trial was irrelevant. Okay. It was the law of the case in 2008. And
so you would agree that as far as that statement in the order is concerned, that the trial judge erred?
No, I don't. I think it's a
on
matter
the relevance issue.
No, Judge. I think that's in a matter for the judge's discretion under the Florida rules, and the judge has wide latitude under those rules to award appropriate costs. But to answer your other question, Judge, we cited for the court two Maryland cases.
Goldstein and Maryland?
I'm sorry?
From the state of Maryland?
Yes, Judge.
Okay.
Goldstein and Barron.
What about Florida? What about
Judge,
Florida?
we didn't find a case similar to our own that's already been heard in the state of Florida. We did not. But we found two cases, the Hawes case from Maryland and the Goldstein case from Maryland. And Judge, eerily...
Could it be that there's no authority in Florida because, it's just not appropriate on an appeal of an order denying costs to come in and attack everything that happened leading up to the judgment and ask the trial court to set the judgment aside based on constitutional issues?
I think it could be, Judge, that if you find fundamental error based on a jury considering the same issue, first one jury and then the other, it's appropriate to bring it to the court's attention.
Okay.
And that's what we did. Thank you.
Thank you, counsel. Anything further?
Just a moment, Your Honor. The merits of this case were resolved in 2008 when the second jury rendered its verdict. That was reduced to a judgment, and they appealed that. That was resolved by this court more than 2 years ago. The only thing we're properly here before today is to decide if the trial court erred in not awarding Howard costs associated with the earlier trial. We submit the trial court did err, and we provided the court with some authority in that regard. We asked the court to remand this matter back to the trial judge for further proceedings.
All right, thank you.
Thank you.
Thank you, counsel.